I woke up thinking about Agent Cooper from Twin Peaks this morning and how much Agent Cooper loved black coffee. I mean, the character of Agent Cooper loved black coffee. And I relate to that because I grew up in a household where coffee was a big deal. My dad started drinking coffee when he was like 5 years old. And for me growing up, drinking coffee seemed like an important aspect of masculinity. Although I think the younger generation doesn't, they're not into it, but I'm into it. I want to talk a little bit about a case that was in the Ninth Circuit this week where there was a denial of a petition for en banc rehearing. And it's a kind of a complex and interesting case about religious values and objections to requirements of vaccination. And that's a controversial subject. And I wanted to talk about it in a little detail and a little more slowly than I've been talking about stuff on social media lately, because I'm tired of making 90-second long little clips to address things that are actually quite complicated. This case is called Detwiller versus Mid-Columbia Medical Center. And the basic idea of the case, well, before I get into the facts of the case, what I want to say about the case that I think is interesting is just the way in law, a constitutional argument that benefits one side of a political spectrum can come back around in another context in the future and benefit a different side of the political spectrum or a different segment of the population. And one of the things I think is fascinating about law is exactly this idea that things recur. It's not one and done. It's not a decision that has no implication for the future, but at least ideally, if it's done well, law is the system where we're going to see patterns recur. And so the analysis in any given case is important because the analysis will come back again in the future. So this case is about, as I said, vaccination requirements. And this individual who worked for this hospital in Oregon, Christian in her orientation, has strong values about, ostensibly, about putting stuff in her body, including the COVID vaccine. So she didn't want to take the COVID vaccine. And I want to say, for what it's worth, that I disagree personally real strongly with that perspective. I think objections to COVID vaccines are kind of silly, and objections to PPE are kind of silly, given the global, very serious health crisis that COVID was. I think sometimes there are bigger fish to fry, even taking into account the fact that these are religious-based objections. But that's just my personal opinion. And the point of kind of what I'm trying to say in this video is that maybe I'm wrong, that maybe there's more than one way to look at stuff. And the challenging thing is to come up with some kind of workable rule that can fit many different situations and accommodate many different perspectives. That's what's so interesting about it, because people do have really different perspectives on this stuff. At any rate, plaintiff in this case says to her employer, I don't want to get the COVID vaccine even though you mandate it. I'm invoking a religious exception. Employer says, okay, fine. Don't get the vaccine, but you do have to wear PPE while you're on the job, and you have to do testing. And the testing involves getting a swab, like the COVID test we're all familiar with, but this test, the swab has something called ethylene oxide on the Q-tip. And the plaintiff says, wait a minute, ethylene oxide, that's carcinogenic. I don't want that in my body. I don't know, is that carcinogenic or not? Wikipedia says it is. I assume that's true. And sort of the crux of the whole thing in this case is that this employee says, not only is it carcinogenic, but I've prayed about the fact that it's carcinogenic, and God doesn't want me to allow this harmful stuff into my body. Well, the Ninth Circuit originally, so backing up for a sec, normally in the Ninth Circuit, what's going to go on is there'll be a panel of 3 judges, and those judges will decide the case. But sometimes, if the parties don't like how the case is resolved, they will petition for en banc review. They'll say, I want the whole Ninth Circuit, all the judges for the Ninth Circuit to weigh in on this issue because it's so important. It needs a reconsideration and so forth. So you petition for that. Sometimes the Ninth Circuit en banc, sitting all the judges together, will agree to reconsider the case. In this case, in the Detwiller case, that petition was submitted and it was denied. But in the original hearing of the appeal, what the appellate court said was, your concern around the carcinogenic quality of this stuff, ethylene oxide, is essentially secular in nature. It's not really a religious principle. It's something you looked up on the internet and you found out that it's carcinogenic. So if we let you call that a religious conviction, then haven't you just turned the entire world into the realm of religion, such that you can turn any preference at all that you might have into a religious, quote unquote, conviction? And what the panel said was, a complaint must connect the requested exception with a truly religious principle. And the word truly is doing a lot of work there, right? Invocations of broad religious tenets cannot on their own convert a secular preference into a religious conviction. Okay. In some ways that makes sense, right? Because, as I say, we don't want folks to be able to say, for example, I believe in the flying spaghetti monster. The flying spaghetti monster doesn't want me to have to wear clothes. Therefore, I don't have to wear clothes. That's not I'm going to posit that that's not a truly religious principle. That's just nonsense that I'm tacking on to a made-up religion. And so I don't think we want that. But what the dissenters from the denial of en banc rehearing point out is courts aren't generally in the business of weighing in on what's truly religious and what isn't truly religious, because that's not the area of expertise of courts. The dissent says the effort to have courts divide religious and secular motivations is not workable doctrinally or practically. And the dissent goes on to say the court's reasoning, in other words, the 3-judge panel's court's reasoning, gives no credence to Detwiller's claim that she received revelation from God that informed her health choices. What about that? I don't have an answer to this one. I don't think it's a clear win or a clear loss. I just see it as a problem. But the frame of reference that I bring to it is this. I work sometimes on cases involving incarcerated people who claim that they have religious values that are being infringed by the policies or the restrictions of a prison, right? And they too assert that they have true beliefs. But the courts will, in the case of incarcerated people, say, well, there's limits, of course, to what religious values can amount to. And the classic example, which you can look up on Lexis, and maybe I'll plug it into this video. The classic example is you can't have a church of surf and turf, of course, that requires you to be fed lobster and steak. That would be nonsense because you're just an incarcerated person. You couldn't possibly have a true religious conviction that you needed to eat lobster and steak all the time, right? Well, maybe so, or maybe not. It seems like if we really believe, following the dissent's language, that we have to give value to having received revelation from God, and that we can't draw a distinction between the truly religious and the merely secular preference, then my incarcerated clients are going to be eating a whole lot better. I'm just saying. At any rate, that is what I'm thinking about. I think it's a fascinating case. I don't, as I said earlier, I don't agree at all with the sort of public health take on people who wanted to get out of what struck me as very minimal public health measures related to COVID. But I do think that these questions of drawing a line around religious preferences are actually really complicated. And I actually really appreciate the fact that our courts, on both sides of this debate, our courts are trying to sort it out in a way that gives space to the reality in our society that people look at this stuff very differently. Not saying, you're a moron, your attitudes are nonsense, or you're an idiot, you don't understand science, or whatever, but just saying, look, there is a broad range of values in our society. Religion is one of them, and we need to have a structure that accommodates all this stuff because these problems come back over and over. All right, thanks for listening. I hope you have your coffee and have a good day.